All right, peace and blessings. I'm going to continue to read Gary Northington's Citizen Grand Juries. This has also been uploaded to his webpage. He refers to an article written by Larry Klayman on April the 30th, 2018, titled Time to Resurrect Citizens Grand Juries. So if you just type in Larry Klayman, Time to Resurrect Citizens Grand Juries, you can find that article, but he included a copy of that article in a letter that he sent me, but this correspondence comes from JPay email. From Gary Northington on 8/10, today is, I think, the 13th, 2018. Citizen Grand Juries. Goes with Klayman article sent snail mail via August 8th. Dear Brother Rudy, recently, Patriot attorney Larry Klayman put out a flyer on the right of normal citizens to impanel a grand jury separate from the public office mafia. Similar to the procedure described in one of Pat Shannon's books, Klayman cited U.S. v. Williams 504 U.S. 306 U.S. 36 1992, written by the late and great Justice of the U.S. Supreme Court Anton Scalia. Relevant Supreme Court text to explain Klayman's article is as follows. The grand jury is a constitutional fixture in its own right. The whole theory of its function is that it belongs to no branch of government, serving as a kind of buffer or referee between the government and the people. Although the grand jury normally operates, of course, in the courthouse and under judicial auspices, in its institutional relationship with the judicial branch has traditionally been, so to speak, at arm's length. Judges' direct involvement in the functioning of the grand jury has generally been confined to the constitutive one of calling the grand jurors together and administering their oaths of office, U.S. v. Williams 504 U.S. 3647 1992. Unlike a court whose jurisdiction is predicated upon a specific case or controversy, the grand jury can investigate merely on suspicion that the law is being violated, or even because it wants assurance that it is not. It need not identify the offender, its suspects, or even the precise nature of the offense it is investigating. The grand jury requires no authorization from its constituting court to seek a grand jury indictment, and in its day-to-day functioning, the grand jury generally operates without interference of a presiding judge. It swears its own witnesses. Fed our crime, page 6C, and deliberates in total secrecy. Williams 504 U.S. at 48. The grand jury cannot compel the appearance of witnesses and the production of evidence, and must appeal to the court when such compulsion is required, and the court will refuse to lend its assistance when the compulsion the grand jury seeks would override rights accorded by the Constitution or even testimonial privileges recognized by the common law. Even in this setting, however, the court insists that the grand jury remain free to pursue its investigations unhindered by external influence of supervision, so long as it does not trench upon the legitimate rights of any witnesses called before it. Williams 508 U.S. at 48. The Fifth Amendment's constitutional guarantee presupposes an investigative body acting independently of either prosecuting attorney or judge. Williams 504 U.S. at 49. Any power federal courts may have to fashion on their own initiative rules of grand jury procedure is very limited. 1. Not remotely comparable to the power they maintain over their own proceedings. Williams 504 U.S. at 50. The common law of the grand jury is not violated if the grand jury itself chooses to hear no more evidence than that which suffices to convince it had an indictment is proper. Williams 504 U.S. at 53. Justice Scalia took the grand jury status back to original intent of the founding patriots. Generations of communist judges have unlawfully legislated to weaken the original intent of the grand juries. The communist unlawful judicial legislation is contrary to Article 1 of the U.S. Constitution, which says all legislative powers herein granted shall be vested in Congress of the United States, which shall consist of a Senate and House of Representatives. U.S. Constitution, Article 1. Any law or judicial ruling contrary to legislative intent of the Founding Fathers is invalid upon inception. Marbury v. Madison, 5 U.S. 137, 180, 1803. Therefore, Justice Scalia corrected decades of left-wing judicial abuses. This raises questions if alleged accidental death of the Honorable Justice Scalia was in truth an accident when considering the ongoing intended coup d'etat by radical leftists since November of 2016. Was Scalia's death a CIA hit by admitted communist John Brennan? Should a citizen grand jury be assembled on this intended coup d'etat of John Brennan, HRC, et al.? God bless the Republic. No king but King Jesus. We shall prevail. GNW. Matthew 16:18, Luke 10:19, John 16:33, 1 John 2:13, 4:4, 5:4 through 5, Revelation 17:14.